Action in rem, a legal action targeting specific property. Example, a case filed to settle a dispute over the ownership of a piece of land. The court's decision will determine who legally owns the land, and this judgment will be binding on anyone who later claims an interest in the property. Adequate remedy at law, legal remedies, typically monetary, sufficient to right a civil wrong. Example, in a breach of contract case, the court determines that money damages are sufficient to compensate the injured party, negating the need for specific performance or other equitable remedies. Adjourn, to postpone court proceedings to a later date. Example, during a trial, the judge decides to adjourn the proceedings for 2 weeks due to unforeseen circumstances, such as the sudden illness of a key witness, with the aim to reconvene once the situation is resolved. Admiralty and maritime claims, legal issues related to maritime activities and navigation. Example, a lawsuit involving a shipping company over a collision at sea. The case will deal with laws governing navigation, maritime commerce, and related injuries or damages. Affirmative defense, a defendant's assertion of new facts and arguments to defeat the plaintiff's claim. Example, in a defamation lawsuit, the defendant may use the affirmative defense of truth, asserting that the allegedly defamatory statements are actually true, which, if proven, would negate the defamation claim. Amendment of pleadings, changing pleadings to correct errors or add new information. Example, after initially filing a lawsuit, the plaintiff discovers an additional party who should be included and amends the complaint to add this new defendant. Ancillary jurisdiction, court's authority to hear additional claims closely related to the main claim. Example, in a federal lawsuit involving a federal law, the court also hears a related state law claim because both claims arise from the same set of facts. Answer, a defendant's formal response to a plaintiff's complaint. Example, in response to a civil lawsuit, the defendant files an answer denying the allegations and possibly raising counterclaims against the plaintiff. Appeal of interlocutory order, challenge to a court's ruling before the case is finalized. Example, a party in a lawsuit appeals a judge's order denying a motion to suppress evidence before the trial concludes. Arbitration, dispute resolution process outside court, where an arbitrator makes a binding decision. Example, two companies engage in arbitration to resolve a dispute over the terms of a contract, with the arbitrator's decision being final and binding on both parties. Assignment of errors, listing of errors a party believes occurred during a trial in an appellate brief. Example, in an appeal, the appellant lists specific mistakes made by the trial judge, such as improper jury instructions or admission of inadmissible evidence. Attachment, seizing a defendant's property to ensure satisfaction of a potential future judgment. Example, a creditor obtains a court order to seize a debtor's assets, like bank accounts, early in the lawsuit to secure an anticipated judgment. Attorney work product, materials prepared by or for an attorney in anticipation of litigation. Example, notes and strategy documents created by a lawyer in preparation for an upcoming trial, which are protected from discovery by the opposing party. Cause of action, legal grounds on which a plaintiff files a lawsuit. Example, a person files a lawsuit for negligence after being injured in a car accident, claiming that the other driver's failure to exercise reasonable care caused their injuries. Certificate of service, document proving that legal documents were served to another party. Example, after serving a complaint and summons on the defendant, the plaintiff files a certificate of service with the court, confirming that the documents were delivered on a specific date. Challenges for cause, request to remove a juror for a specified reason, such as bias. Example, during jury selection, an attorney requests the removal of a potential juror who has a close personal relationship with one of the parties, arguing this relationship could bias the juror. Choice of laws, determining which jurisdictions laws apply in a legal dispute. Example, in a contract dispute involving parties from different states, the court decides which state's laws should be applied to interpret the contract terms. Civil docket entries, record of all proceedings and filings in a civil case. Example, the court's docket lists every motion filed, hearing date, and order issued in a lengthy civil litigation process. Civil liability, responsibility for actions or omissions that cause harm or damage, enforceable through civil litigation. Example, a company faces civil liability for producing a defective product that causes injuries to consumers. The affected individuals can sue the company for damages resulting from the product's defects. Civil litigation, legal process for resolving non-criminal disputes in court. Example, a homeowner sues a contractor for failing to complete a home renovation project as agreed, seeking compensation for the incomplete work and related damages. Civil remedy, legal means to enforce a right or redress a wrong in civil cases. Example: a court orders restitution in a case where a party was defrauded, requiring the perpetrator to repay the amount obtained fraudulently. Class action: a lawsuit where a group of people with common interests sues or is sued. Example: several consumers file a class action lawsuit against a company for misleading advertising, representing all individuals who were similarly misled by the company's claims. Class certification: court approval for individual plaintiffs to represent a group in a class action. Example: a court certifies a class action allowing a few affected customers to represent all those impacted by a defective appliance. Clerk of court: court official responsible for managing court records and procedures. Example: the clerk of court manages the filing of documents in a major civil lawsuit, ensuring all legal filings are properly recorded and stored. Closing argument: final summary and persuasive argument by attorneys at the end of a trial. Example: an attorney delivers a closing argument summarizing the evidence presented and arguing why the jury should find in favor of their client in a personal injury case. Complaint: the initial pleading by the plaintiff in a civil lawsuit outlining the basis for the claim. Example: a plaintiff files a complaint alleging that the defendant's negligence led to a car accident causing significant injuries. Compulsory counterclaim: a defendant's claim against the plaintiff arising out of the same transaction or occurrence as the plaintiff's claim. Example: in a lawsuit over a contract dispute, the defendant files a compulsory counterclaim alleging that the plaintiff also breached a different aspect of the same contract. Condemnation proceedings: legal process where the government takes private property for public use, with compensation. Example: the government initiates condemnation proceedings to acquire land for a new public highway, offering fair market value to the affected landowners. Consent decree: agreement between parties to settle a case, approved and ordered by the court. Example: two companies involved in a patent dispute reach a settlement agreement, which the court formalizes as a consent decree, resolving the lawsuit without further litigation. Counterclaim: a claim made by a defendant against a plaintiff in the same legal action. Example: in a real estate dispute, the defendant files a counterclaim alleging that the plaintiff breached the terms of the sale agreement first. Continuing with the concise definitions and detailed examples for civil procedure terms. Court administrator: an official responsible for the non-judicial operations of the court. Example: the court administrator coordinates the day-to-day administration of the court, including managing court personnel, overseeing the court's budget, and implementing court policies. Court of equity: a court that decides cases based on fairness and principles of equity, rather than strict legal rules. Example: a court of equity may grant an injunction to prevent a party from engaging in certain actions, even though the legal remedy of damages would not be adequate to address the harm. Court of general jurisdiction: a court with the authority to hear a wide range of cases, both civil and criminal. Example: a state superior court hears cases ranging from contract disputes to felony criminal trials, having broad authority over various types of legal issues. Court of limited jurisdiction: a court with authority restricted to specific types of cases or issues. Example: a small claims court exclusively handling civil disputes involving limited monetary amounts, such as claims not exceeding $. Cross-examination: questioning of a witness in a trial by the party opposed to the one who called the witness. Example: in a trial, the defense attorney cross-examines the prosecution's key witness to challenge their credibility and the accuracy of their testimony. Cross-claim: a claim brought by one defendant against another in the same proceeding. Example: in a multi-party lawsuit, one defendant files a cross-claim against another, alleging their joint liability in the matter. Damages: monetary compensation awarded to a party in a lawsuit for loss or injury. Example: a plaintiff awarded damages in a personal injury lawsuit to cover medical expenses, lost wages, and pain and suffering resulting from the accident. Declaratory judgment: a court statement that determines the rights of parties without ordering any specific action or awarding damages. Example: a business seeks a declaratory judgment to clarify its rights under a contract, helping to resolve a legal uncertainty without necessarily seeking monetary damages. Default judgment: a judgment entered against a party who fails to appear in court or respond to legal pleadings. Example: a plaintiff receives a default judgment when the defendant fails to respond to a lawsuit, allowing the plaintiff to win the case by default. Defendant: the party against whom a lawsuit is filed. Example: in a civil lawsuit for breach of contract, the party alleged to have breached the contract is named as the defendant. Defense: legal reasons or arguments presented by the defendant to oppose the plaintiff's allegations. Example: in a negligence lawsuit, the defendant's defense might include proving that they exercised reasonable care and thus are not liable for the plaintiff's injuries. Deficiency judgment, a judgment for the balance owed on a debt after collateral has been repossessed and sold. Example, after foreclosure and sale of a mortgaged property, the lender obtains a deficiency judgment against the borrower for the remaining amount owed that the sale did not cover. Demand for jury trial, a formal request by a party in a lawsuit to have the case tried before a jury. Example, in a civil lawsuit involving significant damages, the defendant files a demand for a jury trial, preferring a jury's judgment over a judge's decision. Demurrer, a pleading asserting that even if the facts in the complaint are true, they are insufficient to establish a legal cause of action. Example, a defendant files a demurrer, arguing that the plaintiff's complaint, even if factually accurate, does not legally justify a lawsuit. Denial, a defendant's response in their answer, disputing the allegations made by the plaintiff. Example, in their answer to a lawsuit, the defendant denies each of the plaintiff's allegations, requiring the plaintiff to prove their claims at trial. Deposition upon written questions, obtaining testimony from a witness who is not physically present in court, using written questions. Example, a party takes the deposition of a remote expert witness by sending written questions, which the witness answers under oath. Direct examination, the initial questioning of a witness by the party who called them to testify. Example, in a trial, the plaintiff's attorney directly examines the witness, eliciting testimony to support the plaintiff's case. Directed verdict, a ruling by a judge, taking the decision out of the jury's hands, because no reasonable jury could reach a different conclusion based on the evidence presented. Example, after the plaintiff presents their case, the judge issues a directed verdict in favor of the defendant, finding that the evidence is insufficient to support the plaintiff's claims. Discovery, the pretrial process by which parties gather information relevant to the case. Example, one party requests the other to provide documents, answer interrogatories, and participate in depositions to uncover evidence pertinent to the lawsuit. Discovery disclosure, the process of revealing evidence or information to the opposing party during discovery. Example, a party discloses key documents and lists of witnesses to the opposing party, as required by the rules of discovery. Discovery in aid of execution, process of uncovering a judgment debtor's assets to enforce a court judgment. Example, after winning a monetary judgment, the plaintiff conducts discovery to locate the defendant's assets for the purpose of collecting on the judgment. Discovery rule, a legal principle that delays the starting point of a statute of limitations until the injury is discovered or should have been discovered. Example, in a medical malpractice case, the statute of limitations period begins when the patient discovers or reasonably should have discovered the injury caused by the physician's negligence. Dismissal with prejudice, a final dismissal barring the plaintiff from bringing an action on the same claim in the future. Example, a court dismisses a lawsuit with prejudice after finding that the case is frivolous, preventing the plaintiff from filing the same claim again. Dismissal without prejudice, a dismissal allowing the plaintiff to refile the case in the future. Example, a lawsuit is dismissed without prejudice due to a procedural issue, allowing the plaintiff to correct the issue and refile the case. Dispositive motion, a motion seeking to dispose of part or all of a case, such as a motion for summary judgment. Example, a defendant files a motion for summary judgment, arguing that the undisputed facts show they are entitled to judgment as a matter of law, seeking to end the case without a trial. Diversity jurisdiction, federal court jurisdiction based on parties being from different states and the amount in controversy exceeding a statutory limit. Example, a plaintiff from one state sues a defendant from another state in federal court, with the lawsuit involving a claim exceeding $. Domicile and residence, legal concepts determining the official permanent home of a person, which can impact jurisdiction and legal proceedings. Example, a court determines a party's domicile to decide if it has jurisdiction, considering factors like the party's permanent home and intent to return there. Duty to supplement discovery, obligation to correct or update previously provided discovery information when it is found to be incomplete or inaccurate. Example, a party discovers new information that makes their earlier responses to discovery requests incomplete and provides supplemental responses to the opposing party. Entry of judgment, official recording of a court's judgment in the court's records. Example, after a trial verdict, the court formally enters the judgment into the court record, making the judgment official and enforceable. Entry upon land, the legal process of entering someone's land, often for inspection related to a legal dispute. Example, in a property dispute, a court order allows a surveyor to enter the disputed land to gather evidence. Erie v. Tompkins, a landmark Supreme Court decision establishing that federal courts hearing state law claims must apply state substantive law. Example, in a diversity case, A federal court applies state law to decide a personal injury claim, in accordance with the Erie Doctrine. Excusable neglect, a legal concept where a failure to meet a deadline is allowed due to a reasonable excuse. Example: a party fails to respond to a lawsuit in time due to a medical emergency, and the court finds this to be excusable neglect, allowing the party to file a late response. Execution, legal process of enforcing a court judgment, often involving seizure and sale of the debtor's property. Example: after obtaining a judgment for unpaid debts, the creditor initiates execution proceedings to seize and sell the debtor's assets to satisfy the judgment. Extradition, the process of transferring a person accused or convicted of a crime from one jurisdiction to another for legal proceedings. Example: a suspect arrested in one state is extradited to another state where they are wanted for trial on criminal charges. Failure to state a claim, a legal assertion that the plaintiff's complaint, even if true, does not constitute a legal basis for a lawsuit. Example: a defendant files a motion to dismiss, arguing that the plaintiff's complaint, even if factual, does not amount to a legal claim upon which relief can be granted. Fed. R. Civ. P. A federal rule of civil procedure requiring that pleadings, motions, and other papers be signed in good faith, not for any improper purpose. Example: a party faces sanctions under rule for filing a frivolous lawsuit with no legal basis and intending to harass the opposing party. Fed. R. Civ. P. A federal rule of civil procedure allowing a court to relieve a party from a final judgment under certain circumstances, such as mistake, inadvertence, or newly discovered evidence. Example: a party successfully petitions under rule for relief from a judgment due to discovering new evidence that could not have been found earlier with reasonable diligence. Federal question jurisdiction, jurisdiction given to federal courts in cases involving the interpretation and application of the U.S. Constitution, federal laws, or treaties. Example: a lawsuit filed in federal court alleging a violation of federal civil rights statutes, falling under federal question jurisdiction. Findings of fact and conclusions of law, the court's detailed explanation of the facts it found to be true and the legal conclusions drawn from those facts in a non-jury trial. Example: after a bench trial, the judge issues findings of fact and conclusions of law, explaining the basis for the decision and judgment in the case. Frivolous defense, a defense in a legal action that lacks any basis in law or fact, often raised to delay or harass. Example: a defendant repeatedly files baseless motions and defenses, causing unnecessary delays in the lawsuit, which the court may deem frivolous. Garnishment, a legal procedure by which a creditor collects a debt by seizing property or wages of the debtor held by a third party. Example: a creditor obtains a garnishment order against the debtor's employer, requiring a portion of the debtor's wages to be withheld and paid directly to the creditor. Indispensable party, a party necessary to a lawsuit because a complete and fair resolution cannot be achieved without their involvement. Example: in a lawsuit involving a property dispute, a joint owner of the property is considered an indispensable party as the outcome directly affects their interests. Insufficiency of service of process, a defense claiming that the legal documents initiating a lawsuit were not properly delivered to the defendant. Example: a defendant argues that the lawsuit should be dismissed because they were never properly served with the summons and complaint as required by law. Interpleader, a legal action allowing a party holding property or funds claimed by two or more parties to force them to litigate their claims among themselves. Example: an insurance company files an interpleader action after receiving conflicting claims from multiple parties over the proceeds of a life insurance policy. Intervention, the procedure by which a third party enters an existing lawsuit because they have an interest in the outcome. Example: a creditor seeks to intervene in a bankruptcy proceeding, claiming a right to part of the assets being distributed. Involuntary dismissal of the action, a dismissal ordered by the court when the plaintiff fails to prosecute the case, comply with court rules, or follow a court order. Example: a court dismisses a case involuntarily because the plaintiff repeatedly fails to attend scheduled hearings, effectively abandoning the lawsuit. Irreparable injury, harm that cannot be adequately remedied by monetary damages, often justifying equitable relief such as an injunction. Example: a court grants an injunction to prevent the destruction of a unique piece of property, as monetary compensation would be insufficient to remedy the loss. Joinder of claims, the procedure of combining multiple claims or parties in a single lawsuit. Example: a plaintiff joins several claims against the same defendant in one lawsuit, including breach of contract and fraud, as they arise from the same transaction. Joinder of parties, the process of adding additional parties to a lawsuit who have an interest in the outcome of the dispute. Example: in a lawsuit involving a car accident, Additional drivers involved in the accident are joined as parties because they may be partially responsible for the damages. Joint and several liability, a legal doctrine where each of multiple defendants can be held responsible for the full amount of the plaintiff's damages. Example, in a product liability case, multiple manufacturers are found jointly and severally liable, allowing the plaintiff to recover the full amount of damages from any one of them. Judgment creditor, a party who has won a monetary judgment in a lawsuit and is entitled to collect the debt from the judgment debtor. Example, after winning a lawsuit for unpaid invoices, the plaintiff becomes a judgment creditor and seeks to collect the awarded amount from the defendant. Judgment docket, the official court record of judgments, showing who owes whom and how much. Example, a judgment in a civil lawsuit is entered into the judgment docket, making it a public record and enabling the judgment creditor to pursue collection efforts. Judgment notwithstanding the verdict, JNOV, a judgment entered by a court for one party, overriding the jury's verdict, when the judge concludes that no reasonable jury could have reached the verdict based on the evidence presented. Example, a judge grants a JNOV after a jury's verdict awarding damages in a personal injury case, finding that the evidence clearly showed the defendant was not at fault. Judgment on the pleadings, a judgment based on the pleadings alone, without a trial, when there are no facts in dispute. Example, a court issues a judgment on the pleadings in a contract dispute when the facts outlined in the pleadings show that one party clearly breached the contract. Jury deliberations, the process by which a jury discusses in private the findings of the court and decides by vote the verdict. Example, after closing arguments, the jury retires to deliberate and reach a unanimous decision on whether the defendant in a civil trial is liable for damages. Jury instructions, directions given by the judge to the jury about the legal rules they must follow in deciding the case. Example, before jury deliberation, the judge provides instructions outlining the elements of negligence that the jury must consider in a personal injury case. Laches, an equitable defense that bars a claim when there is an unreasonable delay in pursuing it, and the delay has prejudiced the defendant. Example, a defendant in a property dispute claims laches, arguing that the plaintiff waited too long to assert their rights, resulting in significant hardship or change of circumstances. Limited jurisdiction. Jurisdiction confined to specific types of cases or claims, typically involving smaller monetary amounts or particular legal issues. Example, a municipal court with limited jurisdiction handles minor traffic violations and small claims cases but does not hear felony cases or large civil lawsuits. Magistrate judge, a judicial officer within a federal court who handles preliminary matters and specific cases by consent of the parties. Example, a magistrate judge conducts pretrial proceedings, such as initial hearings and settlement conferences, in a federal lawsuit. Mediation, a dispute resolution process in which a neutral third party, mediator, helps parties reach a voluntary settlement. Example, parties in a commercial dispute participate in mediation, where a mediator facilitates negotiations leading to an agreed resolution without going to trial. Memorandum of law, a written document submitted by a party in a legal case outlining the legal arguments and relevant case law supporting their position. Example, an attorney files a memorandum of law in support of a motion for summary judgment, citing precedents and legal principles that justify granting the motion. Misjoinder, an error in joining parties or claims in a lawsuit. Example, a party argues misjoinder, claiming that certain claims or parties included in the lawsuit do not belong in the same legal action due to lack of common issues. Mortgage foreclosure action, a legal process by which a lender seeks to recover the balance of a loan from a borrower who has stopped making payments, typically by selling the mortgaged property. Example, a bank initiates a mortgage foreclosure action against a homeowner who has defaulted on their mortgage payments, seeking to sell the property to recover the unpaid loan amount. Motion for more definite statement, a request by a defendant for the plaintiff to clarify or specify vague or ambiguous allegations in the complaint. Example, a defendant files a motion for a more definite statement, arguing that the complaint's allegations are too vague to allow for a proper response. Motion for new trial, a request to set aside a jury's verdict and hold a new trial, typically on the basis of procedural errors, incorrect jury instructions, or new evidence. Example, after a trial verdict, the losing party files a motion for a new trial, claiming that significant procedural errors prejudice the outcome. Motion for substitution of parties, a request to replace a party in a lawsuit due to events such as death, incompetence, or transfer of interest. Example, the executor of an estate files a motion for substitution of parties to continue a lawsuit after the original plaintiff passes away. Motion for summary judgment, a request for the court to rule that the opposing party has no case, because there are no facts in dispute and the law is on the movant's side. Example: a defendant files a motion for summary judgment, arguing that the evidence clearly shows they are not liable, and therefore, there is no need for a trial. Motion in limine: a pretrial motion requesting that certain evidence be deemed inadmissible and not presented to the jury during the trial. Example: an attorney files a motion in limine to exclude evidence obtained illegally, arguing that it violates the rules of evidence and should not be shown to the jury. Motion to consolidate: a request to combine two or Motion to consolidate: a request to combine two or more related cases to promote judicial efficiency and consistency in rulings. Example: in situations where multiple lawsuits involving similar facts and parties are filed in the same court, a party may file a motion to consolidate these cases into one, arguing that this would avoid duplicative litigation and ensure consistent rulings. Motion to dismiss: a request by a defendant for the court to dismiss a case for reasons such as lack of jurisdiction, failure to state a claim, or other legal deficiencies. Example: a defendant files a motion to dismiss, arguing that the court lacks personal jurisdiction over them, or that the plaintiff's complaint fails to allege a legally recognizable claim. Motion to strike: a request to remove certain parts of a pleading or to dismiss the case entirely, often due to irrelevant or improper material. Example: an attorney files a motion to strike portions of the opposing party's complaint that include immaterial, impertinent, or scandalous statements irrelevant to the case's legal issues. Motions: formal requests made to the court for a specific action or decision. Example: during a lawsuit, various motions are filed, such as motions to compel discovery, extend deadlines, or amend pleadings, each asking the court for a specific procedural ruling. Notice of appeal: a formal notification to the court and opposing parties that a party intends to challenge a court decision in a higher court. Example: after losing a case, the losing party files a notice of appeal, signaling their intention to appeal the trial court's decision to an appellate court. Oral deposition: a process where a witness provides sworn testimony out of court, in the presence of attorneys and a court reporter. Example: a key witness in a lawsuit is deposed orally, answering attorneys' questions on record, which may later be used in court if the witness is unavailable for trial. Order to compel discovery: a court order directing a party to comply with a discovery request after the party has failed or refused to do so. Example: when a party refuses to provide requested documents during discovery, the opposing party may seek an order to compel discovery, asking the court to enforce the document production. Peremptory challenges: the right of attorneys during jury selection to dismiss a certain number of potential jurors without stating a reason. Example: during jury selection, each attorney uses peremptory challenges to exclude jurors they believe may be unfavorable to their case, based on intuition or strategy, without needing to provide justification. Permissive counterclaim: a counterclaim by a defendant against a plaintiff that arises from a different transaction or occurrence than the plaintiff's claim. Example: a defendant in a property damage lawsuit files a permissive counterclaim for an unrelated breach of contract by the plaintiff. Personal jurisdiction: the court's authority over the parties in a lawsuit, often based on their location, activities, or other connections to the jurisdiction. Example: a court asserts personal jurisdiction over a non-resident defendant because they have significant business operations in the state where the lawsuit is filed. Physical and mental examination: court-ordered examination of a party where physical or mental condition is in controversy. Example: in a personal injury lawsuit, the court orders a mental examination of the plaintiff to assess the extent of alleged psychological damages resulting from the accident. Plaintiff: the party who initiates a lawsuit by filing a complaint in a court of law. Example: an individual becomes a plaintiff when they file a lawsuit against their employer for wrongful termination, seeking damages for lost wages and emotional distress. Pleadings: formal documents filed by parties in a lawsuit stating their basic positions, typically including the complaint, answer, and sometimes a reply. Example: in a civil lawsuit, the pleadings phase involves the plaintiff filing a complaint, the defendant responding with an answer, and sometimes the plaintiff replying to new issues raised in the answer. Preliminary injunction: a temporary court order issued early in a lawsuit to prevent irreparable harm before the case can be fully decided. Example: a company seeks a preliminary injunction to stop a former employee from using trade secrets at a new job, pending the outcome of the lawsuit. Pretrial conference: a meeting between the judge and the attorneys to plan the trial, discuss issues, and attempt to simplify or settle the case. Example: before trial, a pretrial conference is held where the judge and attorneys discuss the evidence, identify key issues, and explore settlement possibilities. Procedural law: the set of rules that govern the proceedings of the court in criminal lawsuits and civil disputes. Example: Procedural law dictates how a civil lawsuit is initiated, the timeframes for responses, how evidence is presented, and the conduct of the trial, and the steps for appeals. It ensures fair and orderly legal proceedings. Proximate cause, the primary cause of an injury in tort law, which is a necessary element to establish liability for the injury. Example, in a car accident case, the plaintiff must prove that the defendant's reckless driving was the proximate cause of their injuries to hold the defendant liable. Quasi in rem actions, legal actions based on the jurisdiction over a defendant's property within the territory, rather than jurisdiction over the defendant personally. Example, a court exercises quasi in rem jurisdiction by attaching a non-resident defendant's property located within the state to satisfy a claim against them. Real party in interest, the person who possesses the right being enforced in the lawsuit. Example, in a lawsuit to enforce a contract, the real party in interest is the individual or entity that holds the rights under that contract. Record on appeal, the complete set of documents, evidence, and transcripts from the trial court that are reviewed by an appellate court. Example, when appealing a court decision, the appellant compiles the record on appeal, including all trial documents, exhibits, and hearing transcripts, for the appellate court's review. Recusal of judge, the process by which a judge voluntarily steps down from hearing a case due to potential bias or conflict of interest. Example, a judge recuses themselves from a case where one of the parties is a close personal friend, to avoid any appearance of bias. Redirect examination, further examination of a witness after cross-examination, focused on clarifying or rebutting points raised during cross-examination. Example, after a witness is cross-examined by the defense, the plaintiff's attorney conducts a redirect examination to clarify statements and strengthen the witness's credibility. Relation back, a legal doctrine allowing amendments to pleadings to be treated as if they had been filed when the original pleadings were filed, often important for statute of limitations purposes. Example, a plaintiff amends their complaint to add a new claim, and the amendment relates back to the date of the original complaint, thus avoiding a statute of limitations issue. Relief, the remedy or benefit sought by a plaintiff in a lawsuit. Example, in a breach of contract lawsuit, the plaintiff seeks relief in the form of monetary damages and specific performance of the contract terms. Remedy, the enforcement of a right or compensation for the violation of a right in a legal action. Example, a court orders a remedy in a trademark infringement case, including an injunction against the infringing party and monetary compensation for damages. Remittitor, a process where a judge reduces the amount of damages awarded by a jury if it is deemed excessive and unsupported by the evidence. Example, after a jury awards an unusually high amount in a personal injury case, the judge orders a remittitor, reducing the award to an amount more consistent with the evidence presented. Removal action, the transfer of a case from state court to federal court, usually requested by the defendant. Example, a defendant in a state lawsuit involving a federal question opts for removal action to have the case heard in federal court, believing it to be a more appropriate forum. Request for production of documents, a discovery tool requesting the opposing party to produce specific documents relevant to the case. Example, an attorney sends a request for production of documents to the opposing party, seeking emails, contracts, and other records pertinent to the legal dispute. Requests for admissions, a discovery tool asking the opposing party to admit or deny certain facts or the genuineness of documents, simplifying trial issues. Example, a party in a lawsuit serves requests for admissions on the opposing party, asking them to admit the authenticity of a contract and the occurrence of certain events. Responsive pleading, a pleading filed in response to an initial pleading, such as an answer to a complaint. Example, after being served with a complaint, the defendant files a responsive pleading, answering the allegations and possibly raising counterclaims. Rule sanctions, penalties imposed for filing frivolous lawsuits or pleadings, or for other misconduct violating Federal Rule of Civil Procedure. Example, a court imposes rule sanctions on an attorney who filed a baseless lawsuit merely to harass the opposing party, ordering the attorney to pay the other party's legal fees. Rule B. Motion to dismiss, a pretrial motion requesting the court to dismiss a case for specific procedural reasons, such as lack of jurisdiction or failure to state a claim. Example, a defendant files a Rule B. Motion to dismiss, arguing that the court lacks personal jurisdiction or that the plaintiff's complaint fails to allege a valid legal claim. Scope of discovery, the extent to which parties can obtain evidence from each other in a lawsuit, limited to what is relevant and proportional to the case. Example, in a breach of contract case, the court limits the scope of discovery to documents and communications directly related to the contract terms and performance. Service of process, the formal delivery of legal documents, such as a complaint and summons, to a defendant, notifying them of the legal action. Example: a process server delivers the summons and complaint to the defendant, ensuring they are officially informed of the lawsuit and the need to respond. Sheriff's sale: a public auction of property seized by a sheriff to satisfy a judgment, often in foreclosure or debt collection cases. Example: after a foreclosure judgment, the sheriff conducts a sale of the debtor's property, with the proceeds going towards paying off the mortgage debt. Show cause order: a court order requiring a party to appear and explain why certain actions should or should not be taken. Example: a court issues a show cause order to a party who has failed to comply with previous court orders, demanding an explanation for their noncompliance. Special verdict: a verdict in which the jury makes findings only on factual issues, leaving the application of the law to those facts to the judge. Example: in a complex civil case, the jury is asked to answer specific questions about the facts, and the judge will then apply the law to these findings to reach a verdict. Spoliation: the destruction or alteration of evidence that may be relevant to an ongoing or potential legal proceeding. Example: a party is accused of spoliation for intentionally deleting emails that were requested in discovery, potentially affecting the outcome of the case. Standing: the legal right to bring a lawsuit, based on having a sufficient connection to and harm from the law or action challenged. Example: an environmental group has standing to sue a corporation for pollution, as its members are directly affected by the environmental harm caused. Standing orders: permanent court orders that apply to a series of cases or to all cases in a particular jurisdiction, often procedural in nature. Example: a court standing order may require mandatory mediation for all civil disputes before proceeding to trial, aiming to encourage settlement. Statute of limitations: a law setting the maximum time after an event within which legal proceedings may be initiated. Example: in a personal injury case, the plaintiff must file the lawsuit within 2 years from the date of the injury, as prescribed by the statute of limitations. Stay upon appeal: a court order to temporarily suspend the enforcement of a judgment pending the outcome of an appeal. Example: after a judgment is issued against them, the defendant obtains a stay upon appeal, preventing the plaintiff from collecting the judgment while the appeal is pending. Stipulation of counsel: an agreement between attorneys on both sides of a case on certain facts or procedures, reducing the issues to be litigated. Example: attorneys stipulate that certain facts are true, such as the authenticity of documents, to streamline the trial and focus on the disputed issues. Subject matter jurisdiction: the authority of a court to hear and decide cases of the general type to which a proceeding belongs. Example: a federal court has subject matter jurisdiction over cases involving federal statutes, while a probate court has jurisdiction over matters of estate and wills. Subpoena: a legal document ordering someone to attend court as a witness or to present documents or other evidence. Example: a subpoena is issued to a company, compelling it to produce financial records relevant to a lawsuit in which it is not directly involved. Summons: an official court document notifying a defendant that they have been sued and requiring them to respond to the complaint. Example: the plaintiff serves a summons along with a complaint to the defendant, marking the formal start of legal proceedings in a civil lawsuit. Supersedeas bond: a bond posted by an appellant during an appeal to stay execution of the judgment and to cover costs and damages if the appeal fails. Example: the losing party in a lawsuit posts a supersedeas bond to delay payment of a judgment while appealing the decision, ensuring funds are available if the appeal is unsuccessful. Supplemental pleadings: pleadings that add or modify the original pleadings, typically do include events or facts occurring after the initial pleadings. Example: a plaintiff files supplemental pleadings to include new facts that have emerged since the original complaint was filed, such as additional damages or parties involved. Temporary restraining order, TRO: a short-term court order issued to prohibit an individual or entity from taking certain actions until a hearing can be held. Example: a court issues a temporary restraining order, TRO, to prevent a company from selling a disputed product until the court can hold a full hearing on the issue. Third-party complaint: a complaint filed by a defendant bringing in a third party who is not originally part of the lawsuit but may be liable for all or part of the claim against the defendant. Example: in a lawsuit for damages from a car accident, the defendant files a third-party complaint against the manufacturer of their car's brakes, claiming the brakes failed and contributed to the accident. Third-party defendant: a party brought into a lawsuit by the defendant who claims that this third party is liable for some or all of the damages the plaintiff is claiming from the defendant. Example: in a construction lawsuit, the contractor, sued by a homeowner, brings in a subcontractor as a third-party defendant, alleging the subcontractor's poor workmanship caused the issues. Venue, the geographic location where a lawsuit is tried, which is determined based on legal rules about where the events involved in the case occurred or where the parties reside. Example, a personal injury lawsuit is filed in the venue where the accident occurred, as it is the most appropriate location for the trial. Verdict, the formal decision or finding made by a jury, reported to the court, on matters or questions submitted to them for deliberation and determination. Example, after deliberation, the jury reaches a verdict in a civil trial, finding in favor of the plaintiff and awarding a specified amount in damages. Video deposition, a deposition recorded on video, capturing the witness's testimony, body language, and demeanor, often used when the witness cannot be present in court. Example, a key witness in a different state gives a video deposition, providing crucial testimony that is later presented in court. Voir dire, the jury selection process where attorneys question prospective jurors to determine if they are suitable for serving on the jury in a particular case. Example, during voir dire, attorneys ask potential jurors about their backgrounds and opinions to identify any biases or preconceived notions that might affect their judgment. Voluntary dismissal, the act of voluntarily withdrawing a lawsuit or a particular claim by the party who initiated it, sometimes without prejudice to refile it later. Example, the plaintiff decides to voluntarily dismiss their lawsuit after reaching an out-of-court settlement with the defendant. Waiver of summons, an agreement by a defendant to waive formal service of a summons and accept that they are aware of the lawsuit. Example, to expedite the legal process, the defendant signs a waiver of summons, acknowledging receipt of the complaint and eliminating the need for formal service. Writ of mandamus, a court order compelling a government official or entity to perform a mandatory or purely ministerial duty correctly. Example, a party seeks a writ of mandamus to compel a local government agency to issue a permit that was improperly denied. Writ of scire facias, an order requiring a party to appear and show cause why some matter of record should not be annulled or vacated, or why a dormant judgment should not be enforced. Example, a judgment creditor files a writ of scire facias to revive a judgment that has become dormant under the statute of limitations. Written interrogatories, a set of written questions sent by one party to another as part of the discovery process, which must be answered in writing and under oath. Example, in preparation for trial, a party sends written interrogatories to the opposing party, asking for detailed information about their claims and defenses.